appellants assert that this is not the case, that there's a significant difference between users of the highway who will come into contact with intoxicated patrons who are driving versus a patron such as in this case where the intoxicated patron is walking. And so the appeal judge stated that there are existing, that Stewart and Petty, the example of Stewart and Petty fits into the broader category of commercial hosts who subject third parties to risk. However, the appeal judge erred in including the appellants into that category because, as Justice McLaughlin says in Child, the governing philosophy behind this broad category of commercial hosts is the element of risk. And that element of risk is lacking where an intoxicated patron is walking as compared to when an intoxicated patron is driving.
Would there not be a risk even inside the hotel, for example, if patrons are allowed to get intoxicated, that they may really seriously injure another patron by getting into a fight?
Very, very much so. There's, of course, risks associated with serving alcohol to patrons, and there are many risks. However, at this stage, the appellants assert that the issue is whether it is analogous to the present cases. So in the current situation, the incident occurred outside of the bar. It did not occur inside. And this is a key distinguishing factor when looking at whether the current case fits into an existing category. Furthermore, Mr. Briggs testified at trial that he had consumed alcohol, but as the trial judge stated, and the appeal judge confirmed, quote, "There is no evidence that the alleged inebriation among the crowd on the mall contributed in any way to the incident in question. Moreover, there is a dearth of evidence that the inebriation of either Mr. Donaldson or his assailant was a factor," end quote. So in addition to the fact that Mr. Briggs was footbound and was not driving a motor vehicle, there's also no evidence to suggest that intoxication was a factor. Both Stewart and in Manow versus Jordan House, this was a key factor in those decisions and the establishment of those duties of care. The appellants assert that this is an important case. I think that is evident to everybody, that has wide-ranging repercussions on society. We're talking about establishing a duty of care for alcohol-serving establishments to all third parties who may be injured by intoxicated patrons who leave their establishment. For this reason, the appellants feel that it is necessary to proceed, at the very least, with the ANS test. Stewart versus Petty. The ANS test was summarized by the Supreme Court in Cooper versus Hobart. The first branch of the ANS test requires establishing that the harm to the plaintiff was foreseeable and that there is sufficient proximity between the plaintiff and the defendant to warrant establishing a prima facie duty of care. The second branch of the ANS test allows for the contemplation of residual policy considerations that should negatize the establishment